Good morning. Good morning. Shout out to all my Kimbays and my Kimboos. We are going to get into day, 106? It's day 106. Let me just make sure y'all can hear me. Day 106. Let me just make sure y'all can hear me. All right, so y'all can. What's today? Tuesday. Happy Tuesday. Happy Tuesday. Make sure when y'all come in, y'all drop me some love, share the live. We about to watch this live stream. It usually start at 8:45, but it looks like it's starting at 9. So you already know we be tuning into Cat Note Not Williams. She be having a lot of insight on what's going on. So we will be tuning into her live stream and I will be talking about it as well. So make sure y'all drop me some comments, share the live, and if you are pulling up, make sure you subscribe to the channel. All right, y'all. So they should be starting any minute.
The probation, like, think about that. Not messing up for 15 years. That might sound easy, but messing up is somebody else's definition, not your own. Like, crazy. And that's true on the other end. Fulton County spent their whole budget on this trial rather than fixing their jail, so why would they want to offer pleas? You know, maybe just to get that quick conviction, but I feel like from a media perspective, it would kind of look like a plea. All right, we have a countdown finally. If they offer a plea and it's taken and they're publicizing, hey, this person 105 days into the trial just pled out. I feel like that would signal to people, the public that aren't paying attention, that why would the state suddenly be offering plea deals? It will just bring more attention on the state for possibly flopping this case. I think it would just be bad from our perspective. And yeah, you never know, your probation officer could be on a power high. And probation's expensive. So I might need some education there. I'm not doubting it. But what makes it expensive? Is it because you have to go physically and check in? Do you have to pay certain things? Educate me, chat, because Sweet 88 probation is just set up for people to fail. There just isn't enough probation officers that truly care about trying to help people. I think so too. I mean, TV might like there's those ones that are tripping. Rather, hey, you follow the rules and you're supposed to do. I purposely see to look for like the find the crime type of mentality. Dang, that's crazy. So you gotta dang. lot of research on Michigan and reintegration, the success rate of reintegration, which is not very high in Michigan. And if you have felon status and you get out and you try to go live with someone who might be on government assistance, sometimes even assistance for like public student loans, that person you're going to live with, because you have the felon status, if you need an address and you need to make your address this for your family members that you're going to live with, it could knock them out of their benefits that are in their name only, just because you're residing at the same address. And maybe there's been some, progressive reform on that, since this would have been like 2012 that I was doing this research, because I was still in school. But it was like, how do you get out? You can't go live with your family unless you want to put them at risk of losing the assistance that they need, sometimes even the assistance to finish college. Where do you go live? How do you get back on your feet? How does that help prevent they're on? Okay, hold on. Let's try another stream. Let's try 11 Alive, or let's see if Sylvia's there. I don't see it. Doo-doo-doo. Yeah, 11 Alive doesn't have it either. So still waiting. But it's just crazy. Like, the too long didn't read. My summary of that was, you know, like, when I learned that the
Correct
other
me if I'm
person could lose
wrong,
their
but I
stuff, is
believe that Ford
crazy.
is being proffered to support the position that alleged violations of rules of professional responsibility are sufficient to support disqualification. For a couple of reasons, Your Honor, to disqualify, and then after the June 7th and today, but which Ford cites matters, and also in Georgia, there's in criminal case there. But as it relates to this, all that Ford does is addresses whether two attorneys who appeared pro hac vice violated professional rules. And it's specifically authorizes the trial court to consider those rules when considering. That is, the question was whether the attorney who's not a member of Georgia, and of course that's not the issue here. Ford cited Piedmont Hospital versus Reddick, which had held that it was appropriate to consider the professional rules on a question of disqualification. And one of the claims at issue in that case was whether an attorney for one party violated the professional rules in contact another party's board members and employees. And if true, that was something that the trial court emphasized, that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because this has, and that's Piedmont at 76 through 77. Finally, the court held that a party did not have standing to base a motion to disqualify an attorney to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim, which was rejected, was one entity's claim that an attorney was disqualified because of a conflict of interest, where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication. The testimony code went further, but noted that we had investigated with so that interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we've stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least
Then to me, can you get me something? When can you get me something?
is Friday too late?
You can get me something by Friday.
Oh, thank you.
So Jerry's going to come back Monday. Watch behavior. This is a perfect comment. Watching the insanity from the UK,
And so I
the
assume you have
corruption.
made the determination not to present any further evidence on that one issue about whether the state was aware of the proposition that Mr. Melnick might be representing Mr. Copeland. Is that correct? Okay. All right.
One more thing. We did receive the communication from Mr. Steele regarding proffers and if an attorney.
Or,
He sent it generally. It may
oh,
have
oh, yeah. Oh, okay. No, proffers from an attorney. Okay, yes. Mm-hmm.
And so to the extent that that is the way that, that we would operate, we would to therefore require, if we're gonna put up evidence, we're gonna put it up. I don't know how the court views proffers and I didn't.
Well, I mean, I think that the case stands for the proposition that proffers are fine unless one party objects, in which case then you need to present evidence. And so,
And so if that's the case, we would ask, to any circumstance where proffers, we would, if we have to put up evidence, we don't want to, be dueling proffers with evidence. If it's evidence, it's evidence. But where proffers are okay, I'm okay with that.
okay, thank you. All right, how about on the discrete issue of the phone calls, jail calls?
Yes, Your Honor. So I went back and reviewed what all we covered. So that
Okay.
got through the 5 jail calls the state was introduced Mr. Copeland. And I also confirmed and spoke with Mr. Sharp, Mr. Steele. We were in agreement that we handled those jail calls related to Mr. Copeland on Friday. Well,
Okay, I'm sorry, I just thought there were like 2 things outstanding that y'all said, let us huddle and then we'll get back to you.
Yes, Your Honor.
So I'm incorrect in that recollection.
In relation to the
Jail calls.
Jail calls, yes, Your Honor.
Okay, so, okay. Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to agreement, but y'all haven't told me what that is?
Your Honor, there was some that we agreed on. And there was, other parts where, like, for example, one of them was Detective Gaither. He asked if we could, basically we either agreed or redacted or argued those 5 calls. Very end on Friday.
Okay.
And I will get, Deputy Hilton had the notes from that, and so I will work on, and we'll get those notes from Deputy Hilton.
Okay. All right, so then moving on to our next issue. Yes.
Good morning, Your Honor. Good morning to everyone. I agree with Mr. Atkins, and we spoke last night. I think that the only outstanding issue on the jail calls for Mr. Copeland, the 5, was the redactions, and the court ordered us to look at it and then bring up any other issues with your court. So that's what I have in my
And
notes. And I think,
that's what I'm talking about.
and I think,
So,
yeah, but I don't think that the state or us have done that redaction yet. I think the state was trying to do it. If I'm wrong, Mr. Atkins, please correct me, but that's what I thought we discussed.
Yeah, and so, right when we left court yesterday, we and Mr. Shard spoke about the jail calls, and remember I had asked, we covered everything with it, and we were in agreement.
Yes. That's right. And then the only thing we have to do is the redactions, and we have to look at them. That's my.
yeah, so I think that there was, I mean, I've got highlighted now, I made a ruling on those things. So, okay, so, but yes, there was still something outstanding y'all needed to do. So
Yes.
those 2 little pieces of redaction, I think. And y'all were going to get together on that and figure out whether you could come to agreement.
Yes, Your Honor. I will speak with Mr. Steele, Mr. Sharp. I guess there was some miscommunication because we spoke yesterday afternoon and thought everything was before.
Okay.
I will speak with them expeditiously.
Okay.
to rectify that.
All right, thank you. All right, so then our next sort of big topic we need to sort out is what, if any, part and how we're going to handle the fact that Mr. Copeland gave testimony prior to the motion for recusal, and then further testimony following the motion to recuse. And we all kind of agreed,
Figuring Woody
okay,
out.
things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, you know, these things, these parts of the testimony are okay anyway, then y'all can by agreement say these parts are okay, and we can have all of his testimony thus far to decide what, if anything, you think, how to handle it, and what you think might need to come out, if any part.
Judge, we had been in communication with the defense, and I believe that the last time that Ms. Hilton spoke with Mr. Sharp, that they were representing the defense would get together and see if they came to collective understanding about what it was that they wanted to stipulate to and get back with us. But if I read correctly last night, they indicated that everything beyond the point of Mr. Kendrick's motion, they wanted to do over. If I read that wrong,
I don't know. I mean, if y'all had email communications overnight, I don't know what those would have said. But does somebody want to represent to the court what the defense position is, if it's a joint position?
Your Honor, I can speak on behalf of Mr. Williams, Mr. Stillwell, and Mr. Kendricks. The stance is that everything post the recusal needs to be redone.
Okay.
Just because we
June
feel
12th.
that that's the applicable law, and that's where we're at.
All right. What about Mr. Matthews? What's,
Good morning to the court. On behalf of Mr. Healy, we are in agreement that everything posted with future file should be taken from her.
okay. And then
Harrington says after the 12th.
Ms. DeWilliams, what's y'all's position? Speak into your microphone, please.
Same position as Mr. Matthews, Your Honor.
Okay. All right. So I've got another question for the defense, and that is, I mean, I think that everyone has joined into the assertion in both of the pending motions that I mentioned before, that the
I apologize for interrupting the court. I think there was one more party that.
William, Stillwell, Kendricks, Huey, Ryan. Oh, guess, I don't know. Sorry.
Microphone.
Nichols.
Clearly the forgotten person in this case who should be severed, who continues to object to the admission of any of Mr. Copeland's testimony against Mr. Nichols. So our first position is we object to the admission of Mr. Copeland's testimony against Mr. Nichols. Second position, that if it's admitted, it comes in with a 105 instruction.
All right, I've asked you a couple of times to give me a proposed one.
Yeah, we have it.
Okay.
We're going to give it to you prior to the time the jury comes in, if it comes in, because that's still outstanding. And
Okay.
And number three, we would, as the player, and alternatively, we would join the motions on the floor.
Okay. So on the proposed limiting, I mean, jury's coming back before too much longer. So go ahead and get that to me and the state so that we can contemplate language and whether, I mean, I think it would be appropriate to give. So, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, you know, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great.
Uh-oh.
No chewing gum in class.
Law School
All
101.
right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
And good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two-stage. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, of the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine
What if he's there?
did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. You know, he could choose what he wants to do, and then we would strike everything he said.
Okay, well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Do we, then how do we still say, oh yeah, but I want, you know, some of that testimony? That's still good.
It's a catch-22. Where, how do you solve that?
Communist China's military, built with help from an American, Dave McCormick. As CEO, his Wall Street firm became the #1 foreign hedge fund in China, getting very rich building China's communist military. He put money over country.
Your one smart shop for back to school. More fashion, bigger savings. JCPenney, make it count.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck, your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, you know, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position it was coerced, you know, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a yes, if it was coerced, then we need to redo all of it, or, you know, find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
that's what I thought.
Okay, all right. Just so sounds like, well, then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see if have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial and in Mr. Shart's on Mr. Stillwell's behalf revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him before that time that he has to testify. I'd also point out that his counsel was present.
I know.
So thank you for hearing me.
Okay, well, I mean, I hope that it is not up for debate that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting here charged with RICO for crimes? The statute of which, this statute has run on the overt acts. They're in support of the RICO. And I can't remember right offhand what the other potentially incorrect statement was about. But I mean, some of this is or isn't perjury